The relationship between the federal government and institutions of higher education, whether it's technological breakthroughs, economic breakthroughs, medical breakthroughs, scientific breakthroughs, has been a remarkable success story. And if you get to a point where schools go, we can't operate with this degree of uncertainty on a regular basis without something in the way of robust procedural checks, I wonder if schools start saying, we're going to have to rethink this. And we end what has been a relationship that I don't, even the most ardent critics of higher education have to acknowledge have paid tremendous dividend to this country. Hello, and welcome to Campus Docket, a Volt podcast about the legal challenges reshaping higher education. I'm Scott Schneider, attorney and adjunct professor at the University of Texas School of Law, and I'm joined by Eric Kelderman, senior writer at the Chronicle of Higher Education. Each episode will unpack the key legal developments that matter to higher ed leaders, from student rights and faculty contracts to DEI lawsuits and government oversight. Campus Docket is produced by Volt, the go-to news source for higher ed leaders and decision makers. Remember to visit Volt at voltedu.com and subscribe to Campus Docket on Apple Podcasts, Spotify, or wherever you get your podcasts to make sure you never miss an episode. Let's get into this week's show.
Hey, welcome back to Campus Docket. I'm Eric Kelderman, a senior writer at the Chronicle of Higher Education. Great to see you again, Scott.
Eric, it's good to see you as well.
We're going to do kind of a special episode of Campus Docket. The whole episode is going to be sort of update on really new developments in higher ed, which we'll get to in just a minute. But because the episode's a little different, I wanted to start with a special sort of edition of our icebreaker. And I think this week we should have Scott's top 3 experiences when he was in Japan with his family.
All right. Yeah, we got back from Japan. I guess it's been about a week now. I will say what's not in my top 3 is the jet lag. I feel like I've been operating with half top tied behind my back, if that's a thing you can do for the last week. Oh my goodness. Top 3. This is going to be an odd one. The food in Japan is remarkably good and interesting. I was sort of just blown away, though, by the fact that I could walk into a 7-Eleven and get probably for like $7 or $8 some of the best sushi I have ever eaten in my life. So that was really high up there on my list.
But just to be clear, you haven't compared it with 7-Eleven sushi in the States, right? So we don't know.
Fair point. I occasionally am tempted by a 7-Eleven taquito that looks like it's been spinning on one of those things for weeks, but I've never indulged. Number 2, for me, I was just blown away by Kyoto. Just the city, the people, the scope of it, the history, the geography was just remarkably fascinating city. We stumbled into this blues club I don't know if I told you this story yet, but
no.
We go into this blues club, and there is the guy who's the bartender, and he's wearing a Louisiana Music Factory hat.
Oh my gosh.
Which is like probably, if it's not my favorite, it's in my top 2 of favorite record stores. This one is right outside the French Quarter in New Orleans. And I go, hey, I'm from New Orleans. And he could speak a little bit of English. And he comes, he has these thousands of CDs, and he pulls one and he puts it in front of me. And he goes, this is my friend. And it's a guitar player I know by the name of Jun Yamaguchi, who's from New Orleans.
Oh my God.
It's like literally one of my best friends in New Orleans, a musician named John Papa Grow. And so I'm like, holy moly, what are the chances of this? And
wow.
So his name was Kano. We became really good friends. We took over his club. He took us to all these great restaurants in Kyoto, and we still message each other to this day. It was
That's
crazy.
great. Can we get him on for an episode of Campus Docket? Do you think that'd be
I would welcome his thoughts on this. Oh my God, it was so great. And then I will have to say that for me, look, I like going to bars. I'm from New Orleans, whatever. We went into the Golden Guy in Shinjuku, which is this sort of like block of these very small, tiny bars. And it is a cross section of humanity that comes out. There's a fellow, was sitting there, sorry, drinking Japanese whiskey, which is fantastic, by the
right?
way. And there's a fellow sitting right next to me. He's probably 20 years older than me, doesn't speak any English. We're hitting it off. I don't know how. We're just like laughing at each other. And he goes, I found a way to connect. He takes out his phone and he puts on YouTube and he plays Bonnie Tyler, I Need a Hero.
Oh my gosh!
Me and him, I don't know, it's 2 o'clock in the morning. We just start singing. The whole bar starts singing. That was probably my highlight. It was great. So it's an amazing, it's an amazing country. I will say we went obviously in July. It was remarkably, and this is from a guy from New Orleans and Austin. It was so hot, like a heat and a humidity I'd never experienced before, but very worthwhile. How about
Well,
you? Did you have
excellent.
do anything fun?
No, but I have no fun, Scott. I'm a reporter. Well, I am taking a vacation at the end of next week. We're going to LA for a few days. So
Right on,
not quite
cool.
as far as Japan, but we're going to catch a couple ball games there and I'm going to see the Getty and do a couple other sort of touristy things. Yeah.
I
So I'm
I
looking
I
forward to that.
love well, I love LA. I think that was a song. I can't remember
Yeah.
the fellow who sang it. It was great. And yeah, in a weird like Twitter exchange, the guy who's I think it's Seth Davis, we become Twitter back and forthers, and he was extolling the virtues of Los Angeles, which I had no argument with. I think LA is fantastic. So have fun.
Higher ed is facing headwinds like never before. And with internal teams leaner than ever, you need outside help that knows what you do and can plug into your operations to help in any way you need. From enrollment analysis and support, to bold, brand-driven creative and elite user-focused strategies, Electric Kite can help. So yeah, it's getting windy out there. But that's okay, because kites rise against the wind. Visit electrickite.com to learn more.
Thank you. So let's get into it, though. We've got a lot of really sort of amazing developments in the higher ed legal world in the past week or so. And I think chief among them is the fact that Columbia University made a settlement with the Trump administration to basically it's like a settlement. You're being sued and you settle with your accuser, you pay some damages, maybe you make some concessions on actions. In many ways, it's similar to what a corporation might do. And some of the key items in this are Columbia's agreed to pay more than $200 million in fines to the U.S. government and additionally to close an EEOC investigation. The concessions include comprehensive review of Columbia's portfolio of programs in regional areas, starting with things relating to the Middle East and with a focus on creating intellectual diversity, whatever that's supposed to mean. They're going to go ahead with some restrictions on protests in academic buildings and banning protesters from wearing masks. They're going to remove students from the board that determines student discipline. Not surprisingly, they're going to eliminate basically everything that's related to diversity, equity, and inclusion. And they're going to submit admissions and I think hiring data to the government to be monitored to make sure that they're not violating, I guess, anti-discrimination laws. These are all sort of, I think, in some ways unprecedented. There's going to be a third-party monitor to look over this agreement. A guy named Bart Schwartz from Guidepost Solutions. He's the former chief of the criminal division of the U.S. Attorney's Office for the Southern District of New York. He's quite well known. I can't think of anything close to this that's happened to a university in the United States. And so I guess let's dig into this a little bit, Scott. I mean, are you as astounded by this as I am?
Yes. That was easy. And I want to reframe something you said, and because I think it leads into
Please.
why this is so remarkable. I mean, there wasn't a lawsuit, I mean,
Right.
there was allegations made by the administration, and more importantly, from a leverage standpoint, there was the cessation of grant funds.
Yeah, about $400 million. Yeah.
Yeah, and so it was you know, there wasn't a lawsuit, there wasn't sort of any formal adjudication or even informal adjudication that Columbia had done anything which violated any civil rights statute. So that is, in a word, unprecedented. There's never been an administration, as far as I am aware. I mean, maybe you go back. I'd have to look at some of the desegregation cases in the '60s, but my recollection even of those was there was an extended notice, an opportunity to be heard, and an opportunity to correct before any sort of fines or pulling of funds and all that happened. So that part's remarkable. In terms of terms that Columbia agreed to, there are parts of this that, yeah, there's some precedent. For instance, not having students serve on disciplinary panels is actually somewhat consistent with the position of the Obama administration and Catherine Lehman and some of the Title IX regs. That's not, yeah, that's not completely unusual. Look, the part that is, I was gobsmacked, and I'll just be honest. I was doing a training for a group of university leaders, which was talking about, in part, the compliance space right now. And the part that I just was sort of slack jawed over was the $200 million to settle that case. And I can say without question, I mean, think of sort of the fines that over the years universities have paid around Cleary, in which I can't remember what the biggest one was, but it's maybe $5 or $6 million. Maybe you have that information, but there's also a lengthy investigation process, deal, all of that sort of stuff. A $200 million agreement to pay the federal government. And by the way, sometimes, like, in the past, when there was a really functional and robust OFCCP, they really pushed the envelope in terms of settling cases, sometimes with big businesses. But even that money was distributed to alleged victims of alleged discrimination. I mean, here it's like they're writing a check for $200 million that goes to the federal government. I've never seen anything like that. And I'm going to go a step further. I know I'm never, I try to just call balls and strikes. The precedent that sets is terrible. And I understand the pressures the university was under, but my goodness, have they established a precedent here that I think is going to be really hard for institutions of lesser means to push back on. So it's remarkable. And look, the $20 million that's paid to resolve EEOC claims. Yeah, I mean, is there precedent for that? Sure. There's a process for it, though. In some, EEOC based assessment that there's a pattern and practice of discrimination and things like that, none of which exist here. So the financial components are remarkable. Columbia can put out press releases about, well, the federal government doesn't have a role in basically the academic decision making or hiring of the practices of the university. And I would go, that's PR.
Yeah. Let me just quote here from Columbia University. In part, their response to this was, and I'm quoting here from their statement. It says, "No provision of this agreement, individually or taken together, shall be construed as giving the United States authority to dictate faculty hiring, university hiring, admissions decisions, or the content of academic speech."
Yeah.
But it's hard to see this as anything but putting a damper on the activity, not only of students, right? The speech and actions of students, but also I think faculty as well.
Yeah, and I'll take sort of the low-hanging fruit this. I mean, I'm trying to find the exact language. Part of the thing Columbia agreed to, for instance, was in its admissions process, it wasn't going to use sort of statements about, I'm trying to find the exact language, personal statements, diversity narratives, or any reference to racial identity. Well, look, say what you want. You read the SFFA decision, and Justice Roberts was clear, and there was a carve out for allowing precisely that sort of stuff. So here is, the federal government getting into the weeds of what the an admissions practice at least is at Columbia University, and an admissions practice that has been specifically sanctioned by the Supreme Court. So no, there really is no way. And I know there's some Twitter chatter from some prominent folks, but I don't think there's any way to spin this as a positive for, kind of the historical understanding about the ways in which universities operate. And, you know, I think there are First Amendment dimensions to this, to the extent universities are like corporations and have speech rights. And this is really about Columbia exercising speech rights, and then just fundamental due process, which is just so important. It's just such an important principle in general, but certainly in this space. I
Right. And
I'm flabbergasted.
yeah, I think it's an astounding development. I mean, to your point about, no investigation, no real findings, as part of the settlement, Columbia says this is not an admission in whole or in part by either party. And Columbia expressly denies liability regarding the United States allegations or findings. So, I mean, that's kind of standard language, I think, for a lawsuit settlement. In this case, again, there was no lawsuit. One thing that's also, I think, astounding about this is Columbia frames this as a way to get back its, $400 million in research grants, but not everybody that has had grants canceled is going to get them back. For instance, the Chronicles reported that this agreement will not restore terminated grants from the Department of Education or, in quotes, any other terminated contract. So not even all the researchers are going to be made, whole, as it were, from this agreement. There's still going to be folks who are going to lose their research funding. I want to follow up with a question on you.
Can I
Go
add
ahead.
one wrinkle to this? I mean,
Yeah,
and look,
please.
I don't know how to say this any other way, but I'll just say it directly. I mean, first off, the non-admission when you pay $200 million to resolve something, which by the way, it's $200 million that presumably comes out of the academic enterprise and the experience of students. It's mind-boggling to me. And, outside of there's certainly scandals that we've had over the years where similar numbers were expended to resolve cases. I would say, I mean, Penn State, obviously, Michigan State jumped to mind.
Larry Nassar, right, and the
Yeah,
Penn State.
but even that funding, I mean, foundationally comes from the state government, and whatever. I mean, it's remarkable. I can't think of a private institution who's ever done anything like this. There is also a governance question here, which I don't know how to wrestle with, and maybe we need to bring on a guest to do it, which is Claire Shipman was an amazing journalist. And, I'm assuming because of her background in journalism, that's why she was brought on the board to begin with. And I'm trying to measure my words here. I'm not sure how that qualifies you to run even on an interim basis a university and or to authorize a resolution agreement of this significance. And by the way, my understanding of the $200 million is it's paid out over a period of 3 years as ongoing monitoring obligations. It is a remarkable resolution.
Are you saying you don't think I'm qualified to run a college or university, Scott, because of my journalism background?
I think I would actually push back on that because I think you actually have an understanding because of the journalism you do of how institutions of higher education operate. You have some historical framework and understanding of what's precedented, what's completely unprecedented. And I'm just, I'm not sure, but I don't know enough about her background, but it is remarkable to me that someone who was on the board is acting on an interim basis with really no previous higher ed experience, certainly no governance experience, entered into an agreement this consequential.
Right. I do want to be fair to President Shipman here, which is being on the board. I'm sure she gained some knowledge about how the institution operates, had some knowledge, and certainly any agreement of this sort would have to have the backing of the board, right? In this case, I think she was probably brought in as a sort of seen as sort of a straight shooter, a neutral party who could negotiate and act in good faith with the administration. I'm speculating wildly here, but I think that's probably part of the equation here. I do wonder though, after all of this, after all the money and the concessions Columbia's made, there's no guarantee that the Trump administration is not going to take some further action if they feel like something else goes wrong at Columbia. And who knows what that is? Maybe there are protests this fall over this very settlement. And maybe the administration feels like Columbia doesn't handle that adequately. And then what do they do next? And they're back in the soup.
Yeah, I mean, like, so generally speaking, I liked what you said at the very beginning, and we'll juxtapose this with Nassar and Penn State. I mean, typically when you make a settlement of this sort, you're doing it in the context of litigation. And at some level, what you're buying is peace. I agree that, we're going to dismiss this lawsuit with prejudice. I'm going to release all claims, all of that sort of stuff. To your point, I don't know what, I mean, there's a short term release of funds, albeit it wasn't very clear to me exactly what that breakdown was in looking at the release agreement. But there's ongoing monitoring that's going to be done. And to your point, if we start back in school, what, in 2 or 3 weeks, and there are things university can control. There are things the university can't control. Students being upset and protesting about whatever the issue may be, and the Trump administration going, "We don't think he cracked down hard enough on them, and now we're going to pull funds again." I don't like, to your point. I don't know what has been purchased for $200 million here.
Right. You have to wonder also whether the administration will have an ongoing interest in this situation. Do they just take the win and say, "Well, we showed higher ed how it's done," and then you move on, right? We don't know what kind of attention the administration has or what kind of ongoing interest they're going to take in the situation there. It may depend a little bit on sort of this next thing we're going to talk about, which is the Harvard situation, right? So similar to Columbia, in the spring, the administration made allegations that Harvard had not handled anti-Semitism on campus, had not done enough to quell anti-Semitism, had not responded to that situation after the protests over the war in Gaza. And then in April of this year, the administration sent this long list of demands, even I think really more far-reaching than the ones they've made on Columbia. Harvard took a different tack, of course, we know, rejected those demands, and then filed a lawsuit. And so I think that they were seen as sort of heroes at the moment, right? Taking on the Trump administration. That lawsuit had its sort of first big major event on the 21st, a little more than a week ago. There was a hearing in the federal courthouse in Boston, and both the university and the Trump administration are seeking summary judgment. For the folks in the audience who are not legal experts, tell us what summary judgment is, Scott.
Yeah. So the short version is, in a summary judgment motion, what you say is there are no undisputed material facts. All right. So there's an agreement about these are the material facts, and both sides basically there's no meaningful dispute. And so what you would look at then is this is in essence for the court a matter of determining how the law applies to those undisputed facts. And look, sometimes you typically you would file a summary judgment motion after some nominal discovery or extensive discovery. You say, hey, these are the undisputed facts. We are entitled to a judgment as a matter of law. Court, you don't have to resolve credibility concerns or anything like that. You just have to assess, how does the law apply to this set of facts?
Yeah, thank you. And so, listen, I got to go up to Boston. I was there in the courtroom actually, I was in an overflow room because there were so many people there in Judge Allison Burroughs' courtroom. And I was in a courtroom 2 floors down watching a video stream. There were a couple of dozen reporters there. There were some faculty representatives. There were, and other interested parties who were in that space. And it was packed. It was all full. And Harvard and coincidentally the AAUP, which filed a similar lawsuit, had a half a dozen or so lawyers sitting in the room opposing one lawyer that was representing the administration. So that was sort of I don't want to say comical, but it was interesting to see this posse of attorneys on one side for the plaintiffs, and then the government represented by one lone guy who by the way was a graduate of Harvard Law. And Harvard's, I'll just boil this down. Harvard's arguments boil down to a couple of big things here. And similar to, we talked about due process in the Columbia case, Harvard is arguing basically that the government violated the Administrative Procedures Act. So initially, the government was arguing that Harvard violated Title VI. And Harvard is saying basically the government should have completed an investigation, offered us an opportunity to remedy the violations through a resolution agreement, or an administrative hearing when the university can appeal the government's findings, et cetera. And if they're going to pull money, then they have to basically tell notice and give the university 30 days before cutting any spending. That's sort of the nuts and bolts of how that usually works. The other big thing, of course, in Harvard's arguments is that the remedies that the government wanted were too far-reaching and violated Harvard's First Amendment rights. So I'll quote here: the government demands on Harvard, at the core of Harvard's constitutionally protected academic freedom, because they seek to assert governmental control over Harvard's research, academic programs, community, and governance, and they bear no relation to Harvard's federal funding. That's a quote from their complaint. So, and we should note here that when Harvard filed a lawsuit, the immediate reaction of the government was to freeze about $2 billion in funding. This was almost all, I believe, NIH funding that went to medical research, by the way. And that was a big point of contention for the judge, which is to say, she asked, well, how does this funding have anything to do with your claims of anti-Semitism, right? If it's a Title VI violation, in theory, you should be cutting money that's related to the problem at hand. The government, interestingly, I thought it was a fascinating turn. The government, though, it started out arguing that weeks ago that Harvard had violated Title VI, they've sort of shifted their tack, and now they're saying that, in essence, that the university shouldn't even be filing its case in the federal district court, but instead in a U.S. Court of Claims, which handles more common contract disputes with the government. The Trump administration's representative from the Department of Justice said the Trump administration had simply changed its funding priorities and should instead be giving this money to other colleges where anti-Semitism isn't a problem. That's their argument. So they're basically saying this is really all about the money. There's no constitutional violation that we've committed, and so this should be handled in the Court of Claims. The judge really, if you read any coverage of this, you'll note, our listeners will note that the judge was not buying that at all. And one of her responses was, if the administration can base its decision on reasons connected to protected speech, she said the consequences for constitutional law are staggering. So basically she was saying, if you take this to the Court of Claims, then Harvard has no way to contest this as a constitutional claim in the first place, right? So it was a fascinating hearing. It went on for 2.5 hours. And I think it's fairly certain that the judge, which has ruled for Harvard in other recent cases, is probably going to come down on Harvard's side at this point. What are your thoughts on all this, Scott?
Yeah, I mean, look, I will say prior to this administration, my understanding about cutting funds was there is a process for that. It's laid out in the Administrative Procedure Act, and you need to comply with it before you cut funds. So I think that argument that Harvard is making, I mean, certainly comports with my understanding of the world prior to the federal government in this iteration. Look, I need to add something. Anti-Semitism is abhorrent, right? We all
Yeah.
can agree on that. Um, Before we say an institution is anti-Semitic, there ought to be a process, and a process that people, have confidence in. And look, I'm going to go back to the first Trump administration. I mean, one of the hallmarks of the Department of Education and Betsy DeVos was, whether you agree with it or not, this real fundamental focus on the importance of due process there in the context of institutional determinations of Title IX violations. And,
Right.
in a lot of ways, they probably reined in a number of problematic practices. I mean, we all find sex assault abhorrent, but we also, before we accuse someone of that, want to have a comfort level that they have been provided with appropriate process. And I think that's the fundamental issue here in Harvard is you don't see that sort of process, certainly not in the way you've had it in other administrations, including the first Trump administration. Secondarily, there is this sense, and I think it's real, that an institution like Harvard is being targeted because it is viewed as liberal or left of center or hostile to this administration, which again, that invokes some interesting First Amendment issues. There's also, I don't know, I haven't been privy to the conversations that have gone on between the government and Harvard's counsel, but some of the things that have been floated about the government's role in any resolution agreement, ongoing role in faculty hiring and admissions and things like that seems to fly in the face, some ill-defined, but certainly historically important precedent around institutional academic freedom. Now, look, the kickback you get there or the response you get there is, well, when you enter into agreements with the federal government, you give up a little bit of institutional autonomy. And there's some cases that may support that. At the end of the day, and I've seen the reporting, I didn't get to go to the hearing. I mean, I suspect Harvard is going to prevail at the district court. The case then goes up to the Court of Appeals. Now, I don't know what the time frame for when we'll get a decision.
Both the government and Harvard are asking for some sort of speedy decision. And I think Harvard is hoping to have a decision before September 3rd. Actually, I think both parties are hoping for that, at which point I think the government has argued they can't reverse their decision to freeze these funds. So that's sort of seen as a drop dead date
And
of some kind.
Judge Burroughs is a good judge. I suspect she understands the significance of being timely, and then the matter goes up to, I guess the First Circuit Court of Appeals and perhaps the Supreme Court around, what does injunctive relief look like? But yeah,
Right. There's several interesting twists, I think, and sort of some drama, I think, that could result here around both the timing and sort of the prospects of the case continuing. So I don't know this for sure, of course, but I wouldn't be surprised if Harvard does get a summary judgment, as many people are anticipating, that the Trump administration would immediately try and get the Supreme Court to just stay that decision while it's being adjudicated in the Court of Appeals. That's sort of been their modus operandi with a lot of these other issues, which is to say, the court's going to say, well, we're not going to decide on the merits of this, but we think the administration should have its way for now while this is playing out. That's, I think, That's one possibility that I've heard from folks who are connected to this case. There's some interesting timing issues. In addition to this, not after long after the Harvard hearing, Columbia agreed to settle, and then we saw a flurry of news coverage about, well, we expect Harvard to settle now too, right? There was I think there's some negotiating going on in the media through leaked messages from whomever. The folks that I've talked to on background that are connected to this are asking sort of, if Harvard feels like it's going to prevail, what what incentive does it have to settle at all? I think they would want that summary judgment in their pocket as leverage before they would agree to anything with the government. And then a third very interesting issue, which is this sort of parallel lawsuit that's been filed by Harvard's AAUP chapter. And there's some questions about if Harvard does settle, or well, if Harvard does settle, would the AAUP suit be able to continue? Would they have standing? And how does that affect the dynamic? So there's a ton of like variables in play at this moment that are, way above certainly my pay grade and comprehension. I don't know what you think of any of this.
I think any time there's a case of this magnitude, I mean, there are always settlement negotiations. I mean, I do think, and sorry if I was unduly critical of the Columbia president, but President Garber, I mean, he's an academic. I mean, I think he has more degrees than any human on the planet, has the bona fides, provost, all that sort of stuff. I think he both understands the significance of this. And look, his fundamental fiduciary obligation is to Harvard, not to higher ed writ large. But I've got to think that weighs on him. The impact of this resolution weighs on him. I also look strategically. At this point, especially if we're expecting a decision in the next couple of weeks, from Harvard's standpoint, you go, hey, why don't we wait and see? We have a sense of how the judge is going to come out on this. Maybe wait and if we want to negotiate from a place of some leverage anyway, with a decision in your pocket and maybe some sort of injunctive relief. Yeah, I mean, I saw numbers floated around today, like $500 million. And I go, I don't understand, given the posture of this particular case, how that makes any sense whatsoever. But I don't know all the ins and outs of what they're dealing with.
Right. Yeah. The specifics on what's being negotiated behind closed doors have been sparse. Certainly, nobody who really knows about this wants to be coming out in public, but certainly folks have been talking to the New York Times and the Wall Street Journal and other sort of major papers, I think, to press their case, in the public for whatever it is they're hoping to achieve in this situation. I also wonder too, Harvard already has its name on one of the most significant higher education cases in the past half century, in the SFFA case. They're probably not thinking about legacy here, but do they really want their name on another case that could go up to the Supreme Court and really change the fundamental relationship between the United States government and higher education writ large? There is some indication that certain members of the Supreme Court would be amenable to this idea that these disputes over research grants should only be handled in the Court of Claims. And in which case that would be very difficult because, as it's been explained to me, each of those research grants would then have to be contested individually. And so the institution couldn't go and say, make a broad claim for all of its research funding. It would be really a very challenging situation, I think. It would create another hurdle for the institution to push back against these kinds of actions by the government.
I'll say this, we're in the land of unintended consequences. And one of I have to think that there are a number of institutions that rely on considerable grant funding that if it can be pulled that quickly, and if the remedies are so inadequate, that there have to be schools going, we need to start rethinking our relationship with the federal government, which is, by the way, I don't always agree with some of what the advocacy organizations say about higher ed, but good Lord, this is not even close to a controversial statement. The relationship between the federal government and institutions of higher education, whether it's technological breakthroughs, economic breakthroughs, medical breakthroughs, scientific breakthroughs, has been a remarkable success story. And if you get to a point where schools go, we can't operate with this degree of uncertainty on a regular basis without something in the way of robust procedural checks. I wonder if schools start saying, we're going to have to rethink this. And we end what has been a relationship that I don't, even the most ardent critics of higher education have to acknowledge have paid tremendous dividends to this country. I'm glad I'm not president of Harvard. Those are going to be some weighty decisions that the leadership team of Harvard and the attorneys are going to have to make. But I think that's a really fulsome understanding of all the potential consequences of whatever they do. And by the way, look, if Harvard and Columbia, I hate to put this in pejorative terms, fold, there ain't a lot of hope for many other institutions of higher education. I say that, and you sort of saw this play itself out with law firms, and there were these big law firms of tremendous resources who were immediately entering into conciliation agreements with the administration. And it was these smaller law firms, God bless them, small law firms are the best law firms, who, push back and honestly were successful in the litigation efforts to challenge. But yeah, it would be very disheartening, I think, if both Columbia and Harvard, both of whom have considerable means, end up negotiating resolution agreements, especially along the lines of 200. I saw something like $500 million was floated today. That would
Right.
be
Yeah.
remarkable.
Really astounding amount. I think last on our docket today, the president has signed another executive order. It's called Saving College Sports. And I don't know if the details of this matter so much, but essentially what the administration is trying to do is to preserve non-revenue sports, Olympic sports, preserve athletic scholarships for players in those sports, in particular for women, and to prevent, I guess, abuse of the new NIL structure, right? To prevent third party pay for play payments, that are somehow don't meet the standards of the new name, image, likeness rules. And I think there's some thought to restricting the possibility that athletes can be employees of the institution. So uh, this is according to NPR. The executive order directs the nation's largest athletic departments to maintain, certain numbers of scholarships for women's and Olympic sports, and rein in the lucrative name, image, and likeness deals that have dramatically transformed athlete compensation. I think there's a question. Certainly this is a point of view that the administration is taking. I think the questions are, what if anything does this do? What kind of impact does this have really on the current status of sort of big time college athletics?
Well, I mean, we just had basically almost an hour long conversation about when this administration views reaches its own conclusion that a university is not in compliance with either law or an executive order, that it will take steps to cut funding. And the question on the table is, and I was raising this today in some conversations with some athletics leadership folks, is could the same thing happen here? And if not, why not? And I don't know. And look, I have to say, none of this is what you learned in Schoolhouse Rock. I mean, there are a lot of people I'm a big fan of. What you really probably need here is legislation, right? You need some federal legislation because all of this, FLSA, National Labor Relations Act, other statutes are really rough bits for, and go to Title IX. I mean, we have all these regs that came out in the 1970s. It's a totally different world right now. And do those regulations, which were crafted, I don't know, 50 years ago for a totally different world, how do they apply now? I don't know. And so to me, it's one of these areas that scream for a need for federal legislation. The alternative is what we've had for the last several years, which is basically money being siphoned out of athletics programs into the hands of attorneys. I mean, I'm looking at the payout on the House settlement. I think the NCAA spent $700 million on attorney's fees. They'll fund another 800, maybe $1 billion in plaintiffs' attorneys' fees. That's money in theory that could have gone to the athletics enterprise. So it's a long way of saying there's one option, which is, we just continue to litigate. And I don't see that going away anytime soon. That'll be Title IX and employment. There's another option where there is actual federal legislation that starts dealing with some of these complications. And then there is this wild card, which if you'd asked me this question a year ago, I would say, well, it's an executive order from the president in the absence of legislation. It's pretty much nothing burger. But when you have an administration who now has a pattern of saying, look, we'll pull federal funding if you don't comply, it could be something significant. So it really is a matter of wait and see. And that's why, look, cases like, the Harvard case and how that gets resolved, it matters. And it's not just now. I mean, I keep bringing this up too. I have conservative friends and a lot of folks I have an enormous amount of respect for, but I have to remind them, like, we are, as a country, as a voting bloc, I mean, we are notoriously fickle and the pendulum can swing very quickly. And if this is an appropriate tactic to secure compliance as defined by the administration, what's to stop somebody with completely different compliance priorities from using the same tactic on a go forward basis against other schools? So it's an important issue. And again, what we talked about at the beginning to me has some resonance here in terms of, well, is it a big deal or is it not? Well, it's a big deal depending on whether or not the federal government is willing to pull grant funding from institutions.
It's hard being a college or university president. Higher education leaders face tough choices, and the best path forward isn't always clear. Neither is how to communicate about the choices that an institution has to make. Trusted Voices explores the complex intersection of leadership and communication. Each episode, hosts Teresa Valerio Parrott and Aaron Hennessy chat with university presidents, industry thought leaders, and each other about the latest news in the industry and the challenges and opportunities facing those in the most visible roles in higher ed. Listen to Trusted Voices on the Volt Podcast Network, wherever you get your podcasts.
Right. Is there anything in the House settlement as it stands that you think is going to raise a red flag for the administration?
The part of the executive order that has gotten criticism primarily from the left and from athletes' rights folks is this idea of we're going to, quote, ban any sort of third party payments to student athletes. And interesting, like antitrust questions about that. There was a bit of a brouhaha when a number of collective deals were being vetoed by this new government or this new entity, which is policing basically the House settlement, and that was subsequently after plaintiffs' counsel complained, walked back. But I think that from the athlete's perspective, the argument is, look, we bring a lot of value. We should be compensated accordingly. In any restraint on compensation, whether it's directly from universities or from third parties or from collectives, triggers antitrust scrutiny. And so, yeah, My hunch is that portion of the executive order was certainly not well received by the plaintiffs' counsel in the House
I,
case.
I wonder too to what extent this adds pressure on, in particular, these Power Four football programs to what I think is what we're headed for, which is to simply leave the NCAA to form some sort of association under the college football playoff umbrella and simply become a sport unto itself, which I think Victoria Jackson at Arizona State has been talking about this football basically splitting off and becoming, a thing outside the NCAA.
Well, yeah, I'm not sure. I'm not sure the executive order will have any impact on that. And I
Right.
love Victoria's great, and if she says it, there's probably a kernel of truth there.
She's not responding to this, by the way. That's just been her sort of.
Yeah, I've co-presented with her. She's amazing. Look, I think there's a lot up in the air about what the ultimate final organization is going to look like. And a lot of that, I think, depends on how court cases get decided and whether or not there's federal legislation and what that legislation says. I mean, you already start to see some programs spinning off into, 501(c)(3) organizations, and I go, "What's going on there?" And maybe they're anticipating some future along those lines. It has to be pointed out here, and when we talk about, like, the '70s and, like, for instance, Title IX regulations, quote, unquote, "business model for athletics" is football brings in at a handful, it's not all, but many universities, all the revenue. And because of that interspliced with Title IX obligations, it creates a host of other opportunities. Football basically subsidizes the non-revenue generating sports. And so when you start talking about we're going to siphon college football out of the athletics enterprise and put it into something else, the impact on non-revenue generating sports, I have to think will be profound. And at least there's a big portion of this executive order. Now, how we're going to get there, I don't know, which seems to be concerned with that, the Olympic sports and in particular. So the short version is there's already been a lot of very interesting thinking and a lot of you can already start to see the influence of the NCAA over some of the most fundamental decisions waning. Like, I'll just be blunt. I could be wrong about this, but I think the House settlement was a remarkable settlement. And I have to think it was driven primarily by the commissioners of the major athletics conferences. So I don't want to be hyperbolic, but we're at this really interesting time where the stakes are enormously high in, sort of the future of higher education and the kind of traditional autonomy higher education institutions have been afforded, and the relationship between higher education and the federal government is really at this interesting crossroads. So I will do my part.
Agreed. Agreed. Well, I'm glad you're energized. Listeners don't know what time it is, but for me, it's 7:15 now as we're wrapping up, and which means it's almost my bedtime. So I'm joking. It's not quite my bedtime, but it's getting close. Uh, anyway, well, let's call it a night. And but before we do that, what do you got? What are you looking forward to?
I'm planning a trip to Taos, New Mexico, which everybody tells me I am going to fall in love with and will never leave. I've never been. I have no idea why people are telling me this, because it doesn't look like a lot of fun and there isn't a lot of music. But that's what we're doing, and probably go in a couple
You,
of
you
weeks.
bring the music with you wherever you go, Scott. You bring out the music in people. So
There you go. We're also, I think, in mourning over Ozzy
yeah,
Osbourne for the rest of this week. That's a big
yeah.
loss. What about you, bud? You
Well,
got
like
any
I
big
said, we're
plans?
going to LA in about a week, a little more than a week, and gonna see games in both Chavez Ravine, the Dodgers, and then go down to the Angels Stadium in Anaheim. So not check off a couple more ballparks on my list and, spend some time being a sort of temporary Angelino. So looking forward to that.
That's awesome. LA's great, man. Have a good time.
Yeah. All right. You be well.
You too.
Thanks, everybody.
There you go. Well, look, thanks for tuning in to Campus Docket. You'll find links to everything we discussed today, including related cases, articles, and a full transcript in the show notes and on voltedu.com. Be sure to follow Campus Docket wherever you get your podcast. And while you're there, check out Trusted Voices and Higher Voltage, 2 more podcasts in the Volt lineup that look at higher ed through different lenses. On behalf of the Volt team and my friend Eric Kelderman, thanks again for listening. We'll see you next time.